Invention.
My lord. May I please, my lord?
Yes.
Lordship, I am appearing in item number 50 for respondent number 2, my lord.
15. 50.
50, my lord. This case has been remanded by Honorable Division Bench, my lord. We have to file our affidavit in opposition in this case.
50. Where's orders, my lord? This is orders. Orders, my lord. We will wait. Call it out when the matter comes up. We wait. Yes.
My lord, I beg to make a mentioned memo, my lord, for listing day after tomorrow on 3rd, my lord.
What matter?
My lord, is regarding some personal violation of personal liberty matter, my lord.
Thursday?
Day after tomorrow, my lord. Wednesday, I'm sorry. Second, my lord. Obliged.
May I please, the lordship? My lord, item number 59, my lord, is a part-heart matter, but I need to do some research, my lord. Hearing is concluded. In fact, we are supposed to place some judgments. I have taken concern
59?
59, my lord. Ricardo, my lord.
Ricardo Richmond, dismissal matter. Dismissal. I just need to do one research, my lord, regarding the point, my lord, where major penalty can be given or not, my lord. So I need only 1 week time, my lord, on this.
Okay, 1 week.
Similar prayer for item number 65, my lord. If this matter can be taken after 2 weeks, my lord.
65 cents.
65.
Yes, I am for the petitioner, my lord.
And I am for the state respondent, so that should.
No objection.
No objection.
Highly blessed.
May I please, Your Lordship? Your Lordship, I beg to mention item number 58, Your Lordship.
Yes.
Your Lordship, in this matter, Your Lordship, we had sought for clarifications regarding the amendment.
That house.
Yes, Your Lordship.
So we'll close
We're
it.
still awaiting instructions, Your Lordship.
We received the instructions, they are not sufficient. We may be given just
We'll
last 2
close it
weeks
and
time.
let his house stand.
I'll leave it up to Lordship. Kindly give us a week's time. They've given us a report, but that's not sufficient, the explanation.
Okay. 1 week's request for so.
Obliged.
Enable them to obtain further instructions. Yes.
May I please, Lordship? Lordship, I beg to mention item number 61, Lordship. Learned Senior Counsel is indisposed, Lordship.
What matter is
Lordship, this matter is that construction of IVBF Indo-Bangla border fencing, Lordship.
Which senior counsel?
Mr. T.T. Dingro, Lordship.
Appearing for which respondent?
I'm appearing for HDC, Lordship.
What are the other respondents?
Respondent 8.
Is a link? Is the same? Is this which part?
Lordship, this is the this matter. In fact, is identical to that.
No, which part? Which is in Jawai only?
In Jawai, right lighting area, Lordship. Right lighting.
It seems stretch that one that judgment will be passed now.
Yes.
That,
yes.
what's that?
This case was Mr. Devnath.
Same stretch.
Okay, then after 2 weeks, I think we'll follow the other judgment only.
Yes, Lordship. We'll wait for the outcome of that judgment.
Yes.
Lordship, I beg to mention this item number 60. Lordship, 60. So I've already informed the council, Lordship. This is a Nehu matter, Lordship. I'm praying for 2 weeks' time, Lordship.
No objection, Your Lordship.
Obliged, Lordship.
Your Lordship, I beg to mention item number 62.
No objection, Your Lordship.
1 week, 2 weeks.
2 weeks, Your Lordship.
Yes.
Your Lordship, similar prayer for item number 67.
Your objection?
No objection, my lord.
No urgency.
No, this is a Songsarik matter, my lord. Lordship has already heard this matter.
Why 2 weeks?
Your Lordship, some personal difficulty.
Yes.
Obliged,
Hello,
Your Lordship.
Item number 1.
Yes, Mr. Pandey. What do you have to say? You're appearing. Why are you looking so quizzically?
Good time there.
Yeah, the objections to the review being allowed. I mean, not review, I mean for restoring that it amounts to. Yes.
Because as far as this matter is concerned, what I can gather from the order, the tender was floated on 15th of May 2025.
Right.
And the original date as far as opening of the bids, as it existed was 25th of June.
Yes.
And the writ petition on mentioning was heard on 24.
Yes.
Thereafter, this matter, rightly so, was dismissed on the aspect of delay and latches.
Yes.
Because from 15th of May, the petitioner only at the very fact.
No, forget about that, Mr. Pandey. Do you have what I have to see? What objections do you have to this review application? They're asking this since the date of extended to when?
3rd of July, my lord.
3rd of July.
3rd of July.
So,
and this order the corrigendum was issued on the 24th itself, the day when your lordships dismissed our writ petition. So this was already in contemplation from the date of the pre-bid meeting.
Now the question is, my lords, what is the error apparent on the face of record under Order 47? The petitioner has approached this court with a delay will not be changed. This aspect could not undergo any change if, due to certain circumstances, the department feels that there has to be an extension of time. The conduct of the petitioner has to be seen. From 15th of May till the very fact end, the petitioner did not approach. That aspect will not undergo any change by me extending the time for my own administrative reasons. So, in that sense, we have strong objections as far as the review petition is concerned, and none of the grounds as far as Order 47 are satisfied in this case.
Where's the corrigendum? 207.
That is at page 207.
Where's the
At page 207, serial number 4.
Okay.
And just before that, can you see the second paragraph? Further to RFP issue number so and so, dated 5th May. This should be 15th May. This is the date of the bid. And pre-bid meeting held on 12th June 2025. So pursuant to the meeting where certain queries were made by prospective bidders, the following addendum, corrigendum and clarification are notified as below. All the terms, clauses and conditions etc. mentioned in the RFP stands unchanged except the changes made through corrigendum. Now please see, number 1, they've changed the name of the project from mini secretariat. It is now changed to additional secretariat. Number 2, prospective bidders can apply for the AutoCAD drawings, files, color map, site plan. Number 3, all the serious bidders who have purchased the tender can obtain the technical clarification, including make, model, type, etc. of the different equipment and any other details from the office of the directorate.
By when?
Number 4, my lord?
Does not say by when. I mean,
doesn't say by when. Then they've listed out the new dates. Then can you see number 5? As source of fund is from the Government of Meghalaya, payment at different stages of schedule of payments also depend on availability and release of fund from the Government of Meghalaya to the project. And number 6, professional tax certificate and valid trading license from District Council. The successful bidder can also submit both trading license and professional tax certificate after issuance of so and so before the award of the contract. Now, if your lordships kindly see the judgment, I just want to underscore one particular issue at page 205.
Yes.
So it had been argued on behalf of the state that my petition was a last minute challenge. Now this is what your lordships have recorded and found. On hearing the para 7 minute, on hearing the learned counsel for the parties, it is noted that as submitted the tender conditions contained at clause 3.3 bars a bidder who has a criminal case, FIR, police case, CBI case or any ongoing cases due to corrupt practices from participating in the bid. However, it is also noted that the tender or ITB has been floated as far back as 15th May 25 and the writ petitioner has filed the petition only today itself and sought for urgent listing which the court has allowed, and as such the matter is being considered. On consideration of the entire matter, though the tender condition is questionable as to its appropriateness, the very fact that the writ petitioner has never questioned the same at an earlier stage nor approached the court well within time will surely go against it if the writ petitioner is entertained or any order is passed at this stage, as the same will jeopardize the tender process. So the very basis of the judgment was that it was a last minute challenge. Now kindly see, the pre-bid meeting was held on the 12th. Queries were raised on the 12th by prospective bidder. So department was already contemplating
of
June.
June.
So department was already contemplating making certain changes. Had this information been available to lordships, I'm confident the outcome of this writ petition may have been very different. Well, I'm referring to one judgment on this point.
Even now we are still standing at the.
I don't. But
second is just third is
third, my lord. So my writ petition, had this been known to your lordships, my writ petition was 9 days away from the last date. 9 days away. This is on the issue of discovery of new important matters. Kindly have page 272.
Yes.
Para 28.
Yes.
In state of WB versus Kamal Sengupta, this court emphasized the requirement of the review petitioner who approaches a court on the ground of discovery of a new matter or evidence to demonstrate that the same was not within his knowledge and held thus. At this stage, it is apposite to observe that where a review is sought on the ground of discovery of new matter or evidence, such matter or evidence must be relevant and must be of such character that if the same had been produced, it might have altered the judgment. In other words, mere discovery of new or important matter or evidence is not sufficient ground for review ex debito justice. Not only this, the party seeking review has also to show that such additional matter or evidence was not within its knowledge, and even after exercise of due diligence, the same could not have been produced before the court earlier. So what your lordships only have to consider, that had this information, not just the fact that the corrigendum was issued on the 24th, but the very fact that it was under contemplation by the department and was being considered, would that have altered lordship's judgment?
But then it was not there on record.
My lord, we were not aware of it. So it's a new matter which we have discovered. Had this been known to the state, they could have informed the court. I'm not making any allegations the state did not know.
You can't have.
No, I'm not saying that.
You know that what I call probabilities
Lordship.
and on
Lordship.
what might have happened. The only
Lordship.
thing is that,
But the fact does remain, this was under contemplation from the 12th.
The remains is that even as you're standing there now,
my lord,
the date is on the 3rd as well.
Lordship, true.
You're burdened by the same kind of,
But it would be, lordships would be a little more lenient.
Whether if, within this short period of time, your, whatever representation you file can be addressed by them, adequately, and that is the only thing.
Lordship. So kindly just see, on the 24th when I approached the court, by way of the unlisted motion, had it been brought to your lordship's notice that the department has already issued a corrigendum extending the time till the 3rd, would your lordships have still dismissed my writ petition? That's the only aspect, my lords. I would humbly submit, I don't think lordships would have dismissed, would have at least entertained it, asked them to file an affidavit to justify the conditions that are under challenge in the writ petition.
Yes, Mr. Pandey.
Well, as far as my submission is that the factum of the extension being granted for submission of bids by a week or so will not make any difference.
No, not that. Not extension. No. You're missing the point. His submission is that this corrigendum was issued on 24th, and had it been known to the court or to the petitioner that the date for opening the bids would be, postponed or extended, then maybe the outcome would have been different. There's some forces arguments that way.
No,
suppose that if we had 1 week or 2 weeks time, maybe we would have allowed him just to, put in a small representation and to address that one tender clause.
You also may consider this. On the 24th, the matter was listed on mentioning.
Yes.
The matter was not listed in due course. So, as per his Milord's convenience and the sense of urgency that the petitioner had shown, that matter was listed, and there was no question of seeking any instructions when the matter is listed purely on mentioning, Milords. Point number 2, Milords, there was a pre-bid meeting on the 12th of June. He did not participate or seek any clarifications in the meeting which was held for the purposes of seeking clarifications for the tender. Point number 3, Milords, as far as the tender is concerned, the tender was floated way back on the 15th of May. So if he had any grievances against the tender conditions, he could have approached immediately with promptness. And rightly so, my lords, that aspect has been recorded in the order which has been passed by your lordship. And fourth point, my lords, as far as the tender condition as it stands today, he is barred, my lords, by the fact that there are certain criminal proceedings which are going on against the petitioner. my lords.
That's a
So in
very
that,
that's very clause. He's saying that I'm not been charged. The charge has not been filed. It was a proceeding against me. Whether that will bar, him from participating.
yes. So, my lords, the fact of the matter is that the government, my lords, is the employer which is seeking the kind of people they want to engage with. That
You're
freedom
right.
of
You're right. Of
contract.
course. They're the
that-
owner of the project, so they
Yes.
have that latitude.
So, my lords, if there was any grievance, they should have approached this honorable court, my lords, as soon as the tender was issued. And this is, my lords, a last ditch effort by certain extension, which happens almost in every tender. So that will not give my lords, a cause of action for the petitioner to seek a review. And that doesn't change that he is approached with delay via this writ petition, my lords.
Okay, take down. This is a review application filed by the writ petitioner in WPC number 272/2025, seeking review of judgment and order dated 24/6/2025, whereby the writ petition was dismissed principally on the ground of delay and laches on the part of the writ petitioner in approaching the court or in initiating any action to air his alleged grievance stop. In brief, the petitioner is aggrieved with a condition, namely clause 3.3 of the tender document or instruction to bidders (ITB), which was floated on 15/5/2025, wherein the clause prohibited entities or parties having criminal or police cases pending from participating. Stop. The writ petition permission was the date of as per the schedule given in the tender document. The last date for receipt of the bids was 25th June 2025 at 14:30 hours, and the writ petitioner, the counsel, had sought permission on 24th June 25 itself to move the matter unlisted, which was allowed by this court and later resulted in the order which sought to be reviewed. Stop. Paragraph. Today, Mr. S.N. Learned Counsel has submitted that this review has been filed on the ground that the last date for opening of bids has been extended by the corrigendum dated
24th June 25.
24th
June.
Where's that?
It's at page 207.
Yes. The corrigendum dated 24th of June 2025, wherein the date and time of opening of technical bid has been postponed to 3rd of July 2025 at 4 p.m. Stop. He submits that the fact that he submits that this corrigendum was issued pursuant to a pre-bid meeting held on 12 June 2025, and as such it was well within the knowledge of the respondents on the date when WPC 27225 was moved that there would be an extension. Stop. He submits that this discovery, this is a new discovery which is not within the knowledge of the petitioner, and as the date of the bids has been extended, the petitioner be allowed to at least put in representation, or the respondent directed to file an affidavit as to why the petitioner be not allowed to take part in the proceedings. So, in support of his submissions, the case of so-and-so reported in 2022-17 SEC 255 has been relied upon, which is on the point of ground discovery of a new matter or evidence. Finally submits that this instant case be similarly situated, the same consideration were given to the petitioner. Thank you, Ms. E.S. Pandey, Learned Counsel for the respondents, has in reply has submitted that the situation remains the same, inasmuch as the tender or ITB had been floated as far back as on 15th May 2025, and the petitioner never took part or attended the pre-bid meeting to air his grievances, and the corrigendum which was issued extending the times also marginal, and as such there's no change in circumstances in spite of the corrigendum, and the petition being hit by delay, the review is liable to be rejected. Stop. Having heard the counsel for the parties, it is noted that the last date early fix was 24th of June 2020. 25th of June 2025, and the extension of the date is around how many days only? 25th, that means
8 days, my lord.
It's not more than 8 days. 1, 2, 3.
So I had come on the 24th, then 9 days.
Yes.
Since I had approached this court on the 24th, 9 days.
Of the earlier the earlier fixed date, the earlier fixed date was 25th June 25 for opening of the bids, and the corrigendum has materially only extended the submission of bids by a period of approximately 1 week. In this backdrop, in the considered view of the court, the situation remains the same, as much as there will not be much time for the respondents to address the grievance of the petitioner, further considering the fact that it had not, it's a company, right? It had not taken part in the pre-bid meetings or taken any steps to get its grievance addressed. It is correct that the same may be a new discovery sought to the knowledge of the writ petitioner, but in the circumstances in the circumstances pertaining to the instant case itself, no case for review has been made out, and the same is dismissed.
May I just, as a last attempt, can you have, if I may just direct your Lordship's attention to page 50, my lord, just for a moment.
50?
50 of my review petition. It's what is being submitted is that because I did not participate in the pre-bid meeting, I am sort of ousted from making any challenge. Please see clause 7.7 at page 50. Well, what it says is that non-attendance at a pre-bid meeting will not disqualify me.
Mr. Sen, if you were a diligent, from 15B, you have seen the condition of come.
True.
You know, it happens in all cases. Like many people entertain, you know. Given you can't, 1 week, you can't expect to derail entire process. And it's in public interest.
No, Lordship. Again, the same thing, it's on the 24th. Had it been there, I'm certain Lordships would have taken a somewhat different view in the matter, my lord.
Yes, but then.
Obliged, my lord. Obliged.
Item number 2.
May I please, Your Lordship? Conducting counsel is engaging in another court, Lordship. After some time, Lordship.
This is for condition application.
Yes, Lordship.
Take notice.
Let notice go, my lord, because private party is also there.
Yes. Why you want conducting counsel? To count the number of days.
No,
How many days delay?
341 days, Lordship.
Okay. This is this case. This application is filed for condoning the delay of the day of 1041 days in preferring the review application stop. In that notice issue to all the respondents, Mr. SD is present except notes on behalf of 1, 2, 3. So no further notice called for upon these said respondents. Steps were taken within 3 days. You will file objection.
I will just go through once, my lord. I will say if required.
Yes, after 2 weeks.
Highly obliged, Lordship.
Item number 3.
May I please, Your Lordship? I received the miscase filed by my senior, miscase number 148.
What is this?
My lord, the applicant in the miscase.
The applicant?
Yes, my lord. Is applicant, my lord, is respondent 6 and 7 in the main writ petition.
What do you want?
Matter has gone ex parte against 6 and 7 in the main writ.
You have objection? Against recording the ex parte order of hearing?
No, my lord. Because the necessary party, my lord.
Yes, this take down. This is miscase number 148, 2025 in WPC number 466, 2025. This is an application under Order 9 Rule 7, as per Order 9 Rule 7 for the CPC for recall of vacating the order dated 19/5/2025 passed by this court. Where is the order? Not an extent in this case.
My lord, it's not that.
Why?
I apologize for that, my lord. But
you're seeking the recall of a certain order.
it's a slight defect, my lord.
File a fresh one. Yes. As the miscase defective, Mr. Jindal, please withdraw the same. Will you file a fresh application?
Item number 4.
Liberty allowed, yes.
Please, my lords.
Yes,
Lords, here there is a matter that was pending before my lords concerning a tender by the health department. Now, what had happened, my lords, in this, my lords had at that stage not passed any interim orders. So the technical bid of the my lords, various respondents were opened. Now, what has happened is, my lords, if you have, my lords, kindly have a look at page 7.
Of the miscase?
My lords, of the miscellaneous case.
Yes.
149, my lords.
Yes. 149?
149, 147.
Page 7?
Page 7, my lords. This is, my lords, the bid opening, my lords.
Yeah.
Following the bid opening, which was held on the 9th of April 2025, pertaining to tender for so-and-so, white tender notice number so-and-so, placed below are the findings and decisions thereof, my lords. So then we have, my lords, bidder number 1, who is non-compliant.
Star Medical.
Star Medical, my lords.
Okay.
Bidder number 2, your lordships will kindly see, is compliant only for category 1. Bidder number 3 is compliant for all the categories, my lords. Bidder number 4, again non-compliant. So in essence, my lords, what has happened is there is one successful bidder in respect of this entire bid. That was the initial case made by the petitioners before your lordship, my lords. That the tender itself was, my lords, customized to suit any one person. Well, it's the financial bids are to be opened in terms of this notice, my lords. They are to be opened on the 10th of June 2025.
10th of June?
My lords.
It's already done.
No, it cannot be. I'm sorry, my lords. This is dated the 9/6, my lords. So, at page 7, my lords, would kindly see this is 9/6.
Correct.
Have they
So you think financial bids open when?
Well, as I am instructed that they have not been opened as yet.
But it says here financial.
Well, it was my instructions are that it's not been opened.
So what do you want by this?
At this stage, Millet, we were praying for a stay. I'm not pressing for the stay at this stage, Millet. I was only praying. Let my learned friend file a response, Millet, as to how a single bid, how did the department proceed with a single bid.
I can mean fine.
As my lords are aware, Millet, under the rules of executive business, Millet, if there is a single responsive bid,
then they have to retender.
It has to go in for a retender.
Yes, Mr. Pandey. Oh, you're here again for this matter also.
Yes, my lords, I have been thrown. So, my lords, in this case, my lords, as far as I can also gather, my lords, the bid opening date has already elapsed. So,
let them get instructions, Mr. Paul.
Well, I am not pressing for a stay at this stage, as I've said.
But then we have to know also. I mean,
Well,
it's a public, in public interest, yes. Miss case now 149/2025, WC so and so. By this application, though Mr. Paul does seek state general process, what has been highlighted is that from the bidders who have put in their bids for supply of the medical equipment, etc., only one bidder has qualified in all the category stuff. Accordingly, this is it is also submitted that the financial bids which has been scheduled to be open on
10th of June
have yet to be opened stuff. Mr. S. Pandey appearing for the responsibility instructions list after 1 week.
Well, they may also file a response, Millets, to whatever is the situation.
Let them come instructions first. Instructions suffice.
Well, obliged.
Listen on the 4th.
4th.
Main matters come on the 4th.
4th, Millets.
No,
4th is Millets on
No.
Wednesday. Oh, I'm sorry, Millets. 4th will be Friday.
4th won't be there. Yeah, 1 week. Yeah.
Main matter can also be directed to be listed on the.
I'm not on the 4th. It'll be listed.
Item number 5.
Not here. The instructions have been received, and the IO is also here, madam.
What instructions? Where's the IO?
He's here, madam.
Why we're not giving instructions to the government council when he's asked for them?
But
you come forward here, but an apology. When you see government council representing you in the cases, if you don't give instructions on time, there'll be trouble. You'll be in trouble more. You receive the request for instructions on time.
That's similar.
Then why didn't you furnish instructions?
Actually, the official process has taken.
What official process?
But,
the orders of the court. You get instructions. Get instructions. What instructions have you received?
My lord, it appears, my lord, that the claim of the petitioner is incorrect, my lord. Because there is a court case also where, my lord, the petitioner has not been able to.
His allegations, there's no such court case, nothing is there because
Yes,
the
it
police
is,
given a notice that
No, my lord, it
there's
is-
a court case pending.
My
That's
lord,
the only clarification the court needed, that whether there's what he stated is
Whether
correct or
that
not.
letter says, as per the letter issued by this officer.
Just see the letter.
Annexure 10, my lord.
My lord, you kindly see the instructions, my lord. There is a case is also.
1 second. Annexure on which page?
Page 83, my lord. Here it talks about a non-FIR case number 9 of 2024.
Miller.
Is it before the magistrate,
See, the
which
only
is a
thing-
judicial
only thing I want to know
magistrate?
is that in your letter, accordingly, interim junction orders have been passed by so and so. Established finance case against ownership of suit property be sealed date so and so, but you fail to comply with the court order. What instruction? What case is that?
What is the ad interim injunction?
There was a case.
Yes.
Whether it is non-FIR case number 9 of 2024.
You're not aware of this case?
No, when I checked, there is no non-FIR case number 9 of
No, this is a
2024.
suit.
No suit.
They produced a record of the suit, Mr. Bora.
But the letter says a
Take
non-FIR
down
number,
this,
case number.
Mr. S.I., what's your full name?
This letter does not say a civil suit.
Silverius Khumdej Miller.
Silverius Khumdej. You are in charge, Pilankata Outpost.
Miller.
Has appeared today and has produced set of documents showing
I'll
that,
take time to search
No,
for
one
this.
second. Showing
yes.
that showing that there is a title suit. There's a miscase pending in the Court of Assistant Deputy Commissioner in Nongpo, being miscase number 20 of 2024, when certain orders have been passed up. Mr. Bora.
This has come now, my
Yes,
lord.
no, of course.
The letter given to me
No,
says
see,
differently.
Mr.
I have come
Mr.
with
Bora,
the letter which I received.
Mr. Bora, he'll give you a set of these things, you examine them at your leisure, and you take whatever steps necessary.
When I search, it was not there. It may be
now-
made up that I'll seek for some time to get
This is a court
these copies
proceeding
from the
also
court.
Before the court, as a deputy commissioner.
I'll also
You
get
can't
some
say that
certified
by
copies
magic
from the
they've
court,
come.
my lord.
Suddenly this case is
But then the officer said it is a non-FIR case number 9 of 2024. There is no existence of such case. I am worried about that case.
No, you see this case.
The officer didn't say anything about the title suit
Mr. Bora.
in that letter. Annexer 10 says only about non-FIR case number 9 of 2024.
No, this is regarding his FIR, Miller.
No, that only.
Yes, Mr.
There
Bora,
is no non-FIR case number 9. When I found that it is a non-FIR case number 11 of 2024. I got the copy of the order also.
Please. There were district being miscase 2024, whereas the order has been passed. Accordingly, learned GA to supply copies of the said papers to the counsel for the petitioner. To take instructions.
Yes.
Just after 2 weeks, the personal appearance of S. Khumdej is discharges. Give him a copy. You ask your client then.
Yes.
Item number 6.
Your name is there.
In this item number 6, I am seeking 1 week's time to file the detailed affidavit.
This is which post?
Lordship, this is a sericulture
Okay.
matter, Lordship.
Yes. As prayed for record within the further 1 week's time allowed for detailed affidavit. The time to resolve it according to them.
Lordship.
Item number 7.
Nothing is happening, my lord. Deeply opposed.
7.
And in these contempt matters, they are analogous matters. So we have filed all the required documents, my lord. Now it is for them to take a call, my lord.
Issuing the trade license within what time?
Lordship, I have my learned senior is not present, Lordship. If 1 week's time may be given, Lordship.
Yes, we have already filed, my lord.
It's new, you see, they're like.
Let's hope.
No, they still, they don't, they you know, they are used only to.
So let it come after 2 weeks, let them take a call, my lord.
Yes, on the prayer of the Mr. Paryat, due to an senior, this matter of 2 weeks, yes.
Hello.
Same order till?
49.
Yes, till 49.
49. Item 50.
Wait, my lord.
Yes.
My lord, I am appearing on behalf of respondent number 2, my lord.
Lordship,
I am praying for 4 weeks time to file our affidavit in opposition, my lord.
What happened in this matter? Why Where's order?
It has been remanded by Honorable Division Bench, my lord.
Is the order? Remand order.
Order dated 12/6 of
Okay.
2025 in writ appeal number 16 of 2025.
Okay. Why, on what points are remanded?
Lord, on the question of law, on the maintainability of the writ petition, Lord.
Yes, my lord.
You're for the respondent, Mr. Chaudhary.
Respondent number 2, my lord.
Yes, this matter has appeared today on being remanded by the division bench by order date 12/6/2025. Mr. A. Chaudhary, learned counsel for the respondent number
2.
2. Praise that. What do you pray for?
For filing affidavit in opposition, my lord, 4 weeks time may be
You
granted.
didn't file the first one.
No, my lord.
No, my lord.
Let's
We
say
are
that.
unable to file.
Lord, this aim of Millennium, my lord, appeared and said we'll give an opportunity of hearing because the writ has been filed on the ground that we were not heard prior to passing of the impugned order. So they made a submission, they will hear all parties, and so therefore it was remanded back, my lord.
No, they made submission, they'll hear it, then the matter is disposed of.
Yes.
By this court.
Yes, my lord.
Then what happened after that?
Then, my lord, notices were issued to the parties and they filed appeal and they're raising some question of laws, my lord, regarding maintainability. Let them file an
What
affidavit.
about respondent number 3 then?
Respondent number 1, the same of Millennium, my lord.
No, this is, sorry, respondent number 1 and 2, okay. Right. What about 1?
1 is not appeared. Mr. Sinram was appearing, my lord.
Next paragraph. Next paragraph. A Mr. H. Chaudhary, counsel respondent number 2, prays that we allowed to file a affidavit of opposition. Prayers allowed list up for 3 weeks. What about Emilium? Are they aware?
They are aware, my lord.
Yes. None appears on the respondent one today.
Deeply.
Item 51. 51.
In this case, Your Lordship, the High Court.
Who's the petitioner?
Petitioner is, I think, eight weeks' time was given, Your Lordship, to complete the process of participation in the meetings for consideration of the level of pay of the,
This is the High Court staff matter, my
officials.
lord.
We'll close the contempt now.
No, my lord, let this be pending.
Why? Because that they have taken different turn. It's not a question
Yes,
of
Your
now.
Lordship.
Different orders will follow. You can file again if you feel.
Agreed.
Let it be pending till at least till such time the talks takes place, my lord.
You'll be permitted to take part as a petition.
He's also been
Yes,
permitted to be a part of that delegation.
Contempt even is willful and is due to certain developments in the matter, and the petitioner here is also part of delegation to
With the government, Your Lordship, for consideration of the level of pay.
registry in the different state respondents. At this stage, accordingly, this contempt is closed.
Deeply.
52.
No point keeping it. Yes.
Yes, my lord. I'm appearing for.
Where's the affidavit?
I
5,
need.
6, and 7.
Yes, my lord. I need a little bit more time. I have
Why?
not received the documents.
Last occasion is that we've received the Parwai's comment, Lordship.
We have received comments, but we have not received the documents yet.
How many times have you prayed for time?
Just once, my lord.
Just
No,
the first
Lordship,
time?
since- No, Lordship.
This is the second time that I'm praying for time. Before this, I
Matter
I
was
was not
instituted
there.
in April. Since May, they've been seeking time, Lordship.
MSOA Bank principal is allowed further 2 weeks time to file the affidavit. We have 5, 6, and 7. They expect it on the next date.
Yes, my
They
lord.
should be on board. 1 to 4. Can't see you. Yes.
She will not be filing.
Yes. Oh, it's already recorded. Yes.
53.
Lordship, in this case, I'm appearing for 1 to 3 respondent, Your Lordship. I may be given some time. I have received Parawai's comment. I may be given 2 weeks time. I'll be filing this.
What 3 weeks time? You already took time later on.
2
Who's
weeks time.
appearing for 4 and 5? Who's 6? You're appearing 1, 2, 3. S. Sham. S. Sham. Yes. Mr. Ibrahim.
Yes, Your Lordship.
Where are the other respondents?
I have not seen them yet, Your Lordship.
You have seen them. Who's CL Moplang? MSCL Moplang. 4 and 5, which respondent? What response are those? Yeah?
4 is managing committee, then
5?
5 is principal, then 6 is private respondent.
Okay. Yes, Mr. H. Abraham, please for further on behalf of respondents number
1, 2, and 3, Your Lordship.
For the 2 weeks time to file affidavit. There's no appearance on behalf of respondents 4, 5, and 6. Though on the last date, prayers have been made for filing affidavit stuff. And this is not for 2 weeks for affidavit by the respondents.
Hello, Bletch.
All the respondents.
54.
My lord, I'm praying for some time, my lord.
No objection, Your Lordship.
What about number 4?
Your Lordship, notice has been served to the respondent number 4, Your Lordship, on 6th of May 2025. But till date, no one has appeared on behalf of respondent number 4.
Yes,
So I humbly pray that this matter may proceed ex parte against respondent number 4.
You go, let him file affidavit first. Once
Yes, Lordship.
Yes, Mr. SD, please sponsor for a 2 weeks time for affidavit stock. It is noted that the service is complete. Well, class number 4, no appearance is yet being made on his behalf. List up to 2 weeks for affidavit by 1, 2, 3 for further orders.
55.
Here also, my lord, I'll pray for some time, my lord. This is 2025 matter. I will pray for 3 weeks time, my lord. File my affidavit, my lord.
Yes, Your Lordship. Your Lordship, we have already filed on behalf of respondent 4, 5, and 6.
Very good. MST and Marak submits that. Affidavit has already been filed. When do you file? Today?
Your Lordship, we have already filed on 13 June, Your Lordship.
I'm done with me. I'm done with me. Affidavit has been filed by MST and Marak submits that. Affidavit has been filed on behalf of 1, 4, 5, and 6. Mr. SD prays for
3 weeks
for a 2 weeks time after affidavit is.
I do this, Lordship. 56.
Appearing for respondent number 13, my lord. I'll require another 2 weeks time to file my affidavit, my lord. But it's taking some time in the translation of certain documents.
Lordship, insofar as respondent number 11 and 12 are concerned, Lordship.
Talk off.
Lordship.
Trying to reply, Lordship.
Lordship, they have
You
filed.
filed reply?
Yes, Lordship.
What have you filed? What have you said in your reply?
In fact, my lord, Lordship has the reply. Lordship, para 6 is clear. Lordship.
Where's the reply? Affidavit? Huh? Yes, okay.
Lordship, if I may read para 6, Lordship. That
Yes.
with regards to the amendments made in paragraph 5 and 6, the answering respondent submits that considering the statements of claim that the appellants are not necessary parties in this instance case and their plea to be struck down as being arrayed as the respondent number 11 and 12 so and so, it is submitted that the participation of the applicant in the instant case is necessary to disclose the full facts and circumstances of the case. Now this is relevant, Lordship. No harm, loss or injury would be caused to the applicants and the participation of the applicants is necessary for proper adjudication of the issues raised in the instant case so as to prevent innumerable proceedings, time drain and unwanted costs of this honorable court. So Lordship, they admit that Lordship, there won't be any harm or any injury caused to us. In fact, Lordship, if I can, if I may draw your Lordship attention to the writ, Lordship, they are saying that the tower belongs to us, Lordship. That is totally incorrect, Lordship. The tower belongs to respondent number 13, Lordship. It is only after they complete the installation,
When you
Lordship.
use that tower.
Lordship, we in fact, Lordship, we have to take the tower from them on a rental basis, Lordship, only after the completion of the tower, Lordship.
You are appearing for Indus, Mr. Nomri.
Yes, my lord. Newly
We are not there in the picture.
No, it belongs to us. It belongs to us.
Lordship.
Your Lordship, prior to the filing of this instant case, Your Lordship, we were unaware, Your Lordship, that there were two entities, the Indus, Your Lordship, and the Airtel. That was one reason.
Strike
Your
off
Lordship.
Airtel then.
Your Lordship, Airtel and accessory parties here, Your Lordship.
How?
Your Lordship, the telecom operators, the main reason that a tower is also being
It doesn't work
construction.
that
Your
way.
Lordship.
You see, it works this way. Now telecom operators don't make towers anymore. So that's a different entity, you know. So they make towers, and so multiple, telecom providers, they use that tower to
It's an
avoid,
ISP, Lordship,
you know,
ISP.
instead of having like Airtel has own tower, Jio's own tower, the other things have whatever have their own tower. Basically, that's why they have one tower. So only thing is that as and when you can implement them again, if it is found that maybe they are acting in a way which is detrimental to your interest.
Lordship, but they use, Your Lordship, the tower to
They will use it. They might
provide
not
the
use it.
network,
They
Your
might
Lordship.
use it also. Then you have to make Geo also because they'll use it also.
Yes,
Your Lordship,
correct,
it's
Lordship.
specifically mentioned in the NOC, Your Lordship, that
In fact, Lordship,
the network
if I may,
operator will be
Lordship,
provided. 'Cause
these
it's
towers,
mentioned
Lordship,
Airtel 5G
can be
tower,
used
Your
by
Lordship.
multiple operators, Lordship. It is not only me who can use it. The other companies also are open to take
we
on
know
rental
that.
basis, Lordship.
Lordship, but in the NOC, which has been provided by the respondent number 8, specifically specifies, Your Lordship, Airtel 5G tower.
But we are not there, Lordship, as on date, Lordship.
Yes, and after reply to the application for striking down the names of the what is that? You are read as respondent.
11 and 12, Lordship.
For striking off. No, not 11 and 12.
11 and 12, Lordship.
Where is the petition?
11 and 12, Lordship.
Your performer is one rule.
Lordship,
Yes, Your Lordship.
Yes. 13, you are 13.
13.
13 is in the tower.
Yes, Miss case ka no?
Miss case, Lordship, 120 of 2025. Miss case number.
120. Miss case note here. This is an application for striking of the respondents 11 and 12. That is the managing director, Airtel, and managing director, what is this, 11 and 12? Who are office bearers of Airtel Telecom Company Stop. The prayer for striking off has been made on the basis that the said respondents have no connection with the dispute which is with the tower with respondent number 13, which constructs and erects a tower, and the petitioner. So it is submitted by Mr. S. Chanda that Airtel is only a potential user of any tower erected by such entities. Moreover, he submits they've only been arrayed as pro forma respondents, which reflects the role that they have in the matter. Stop. MS I.M. Lingdoa.
Lordship.
Lingdoa has vehemently opposed the application and has submitted that in the NOC that was sought, specifically mentioned that the same is for an Airtel tower. He further submits that they are necessary parties and their participation in proceedings is absolutely essential.
Moreover, Your Lordship, they've just been arrayed as performer respondents.
Yes, and that is why they've been able to perform respondent stuff. Wanting submissions of the parties and also the respondent number 13, who has categorically submitted number 13, Mr. Philemon Nobri was currently submitted that respondent number 13 is the only entity that is responsible for setting up the towers for which is open for use by multiple telecom operators. The prayer of the respondent number 11 and 12, wherever is allowed, and they are struck off as parties from the array of respondents. Registry to make necessary corrections. The main case, how much more time require?
2 weeks.
In that case, Mr. From, what about the other respondents? What about M. Khairim? No. You won't file affidavit. Yes, MS Khasim, what was respondent number 10? 10 is Adriana Mukhim.
10 is the right now.
And
No.
10 is the right now, Your Lordship.
That is the petitioner. Mukhim is the petitioner.
There are 10 petitions.
Respondent number 10 is
in
the
your
right.
reply affidavit, you made all wrong numbers of the party, I think. Yes. Yes. Okay. In the main case, is 9 or 10. 9 is CM Huma Khairim. 10 is Darbar CM Kibasan. Then you say that MS so for 9 and 10.
She cannot represent both, my lord.
Why?
Because my lord, the issue here is that my lord,
Darbar CM Kibasan.
yes,
10.
That the jurisdiction is of the village falls within this right Nong Tham. So my lord, same council.
But the right Nong Tham will come under CM Khairim.
Yes, my lord. Even the other one, my lord.
You mean there's a
This right
conflict
Maushai
interest
also.
between, there's a conflict between
Maushai
this,
and Nong Tham, my lord.
there's a conflict.
Yes, my lord. So therefore, my lord, separate councils.
Then
Conflict of interest.
he says you're appearing for both. MSF so to take instructions as well. They can appear for both respondents 9 and 10. So up 2 weeks time, further time granted to respondent number 13, represented by so to file affidavit. This after 2 weeks.
Please, Your Lordship.
It becomes a boundary issue.
Your Lordship, I had also filed a stay, Your Lordship, in this case, Your Lordship. Your Lordship may kindly consider my prayer, Your Lordship.
We'll consider the next date.
Lordship.
Yes, the prayer for interim stay shall be considered the next date.
Hello.
You file your affidavit and we consider.
Yes.
I do oblige, Your Lordship.
57.
My lord, status report has been filed, my lord, by the state.
Where's this report?
Well, I would submit it should come by way of an affidavit, and we may be given an opportunity of.
He'll be given a copy.
I have served already, my lord.
Well, just now I got a copy. My whole submission is.
What does it say?
If I can read out, my lord.
What does it say? You know, what
My
does it
lord,
say?
it says, my lord, a written FIR was received at Sela PS from Koi Commander G. Koi so and so, to the effect that on 18/5/2025 at about 20:15 hours, a specific information was given by SIG Devasis Mandal that some miscreants were planning to smuggle cattle through GN 479. Based on the above information, Koi Commander Inspector Joseph Praveen, along with 07 ORS, led an ambush in the alignment of BP number so and so. At about 20:45 hours, the party observed some suspicious movement in the thick vegetation. In alignment of BP number so and so, the party alerted the ACP, which simultaneously rushed to the spot and challenged them. But the miscreants fled away to the Indian side, taking advantage of darkness and thick vegetation. Then the party searched the area and found 25 numbers of medium-sized cattle and 5 numbers of big-sized cattle in the area, and seized all cattle at about 21:50 hours. Further, on 19/5/2025, 2 FIRs were received by Sela PSGD number so and so, one from Sri James Mullar Abraham Neng, son of so and so of Dangsiar Maulong village, PS Sela Iskasils, who appeared at the PS and submitted a written report to the effect that on 17/5/2025 night time, his 14 numbers of cattle went missing from the cowshed, which is located a few meters away from his residence. Also, Srimati Ibasisa War, daughter of so and so, resident of so and so village PS Sela,
appeared at the PS and submitted a written report to the effect that on 18/5/2025, 5 a.m., when she went to the cowshed located at Lingar, Maulong village, she found 16 numbers of her cattle were missing. She had searched for the cattle from the nearby village, but cattle could not be found. Further, an inquiry was conducted, and after proper verification and inquiry, the same was handed over to the rightful owner. It may be mentioned that after 10 days, the cattle were seized. One Srimati Philinda D. Sangma, who informed that she is the resident of Balat, came and inquired about the cattle and claimed that the cattle belonged to her. On inquiring as to how her cattle reached Shala area from Balat, she could not give any satisfactory reply and could not provide any proof that the cattle belonged to her. Further on the inquiry, my lord, further on the inquiry from the headman and secretary of Thliu Umtham, Sri Mithun A. Sangma, Sri Hilary K. Sawain, respectively, as to why they did not report the matter, they informed that they had no knowledge of the cattle, but only on 5/6/2025, Srimati Philinda D. Sangma and 4 persons from their village, namely Rotin R. Marak, Pranap R. Marak, Karsan Marak, Jesse R. Marak, came and met them, requesting to issue one certificate showing that the cattle belonged to Srimati Philinda D. Sangma, so that they could take back the cattle. They also stated that they had no knowledge as to who the cattle belonged, since no report was given to them from the villagers regarding seizure of cattle. So, in good faith and to help their village, they had issued their certificate. The certificate which my learned senior is relying.
So no, Millard.
Nothing.
Your Millard close. Millard, I may be allowed to. Millard, is this a process of the High Court, Millard? A report is produced by some person, and Millard, it may come as an whoever be it, Millard. There must be an affidavit. Millard, there must be an affidavit. I may be allowed to give a rejoinder, Millard.
I have the same report. Status report has been filed.
Whatever, let it be filed. We will give the rejoinder, Millard.
A copy of the same be advance copy. After it be filed by the petitioner within.
If it is filed, give it to my hand.
Advance copy after. When are you going to file it?
I'll file within
1 week. Advance copy to the petitioner. Reply within 2 weeks thereafter.
Well, all right.
After seizing the vehicle, the cows were to hand it over to policemen.
You file the affidavit also.
Let an affidavit come, Millard. Procedure should be followed. All right.
Hearing item 63.
Yes, Mr. Suna.
My lord, this case my lord will recollect that this is a case where the Darbar of the village has opposed the proposed motion bypass, my lord. We have objected the proposal of the government to do the alignments of motion bypass, but however, my lord, of the national highway Shillong Dawki.
No, where?
But my lord, before
no, where exactly is the section, Mr. Suna? Yes. Siat Bakon Im?
Not Siat Bakon, Maushun.
Huh? What are these documents? Who gave this last time? 13 May?
Perhaps maybe during the motion stage, my lord.
But the recent development, my lord, if I may place it, 70% of the construction has gone on.
It's over.
Meaning thereby my case has become
infructuous. So what relief are you entitled to now?
No more, my lord.
You withdraw it?
Withdraw it as infructuous, my lord.
Mr. S.M. Suna has submitted that during the pendency of the instrument application, 70% of the work for the construction of what highway is this? It's called
Shillong Dawki.
You know the number? NH40.
NH40.
Yes, sir. For me. NH40. Of the construction of 4 laning, sorry. Of the stretch. 40% of the 70% of the stretch Siat Bakon to Umsiem.
No, Maushun bypass.
The motion bypass of NH40.
Only few farmer, few agriculture are yet to receive the compensation.
Therefore, submits that as the construction has gone ahead, the matter at this stage is presented infructuous. Of the submissions of the counsel with the petitioner, the matters upon disposal of is being infructuous. You wanted to realign the pass?
Yes, my lord, but
64.
Yes. But yes, Brother Chanda.
This is that matter, second round of litigation, Lordship. Here, in the first round
There are
of
formal
litigation,
parties here, Lordship.
The
The Lady Key.
in the first round of
Where's
litigation,
Lady Keen? Lady Keen? Who's representing 4 and 5?
Mr. Sen,
3,
Lordship.
4 and 5. Yes, MS Black. He's coming.
He's the
He's retired also now.
Lordship, I have retired, Lordship, in the month of May, Lordship. So, Lordship, in the first round of litigation, Lordship, could recollect that Lordship has given some directions, Lordship. Now, contrary to that, Lordship, now what they have done is, Lordship, they have again issued another notice, Lordship, calling us for Lordship, fresh
So,
proceedings,
if
Lordship.
I remember correctly, there was an inquiry done long time ago.
Lordship.
So the court said, since you done, you give your findings to the inquiry.
Lordship, but
Correct.
in,
Is that
but
what
Lordship,
happened?
instead of giving finding, Lordship, they have again issued another memorandum and called us for inquiry, Lordship. Fresh inquiry is supposed to be held, Lordship, which is
Where is
against the
this?
judgment, Lordship, passed by Lordships, Lordship.
Yes, just read that for the time being.
Lordship, if Lordship comes to page 48, Lordship, 48 of the writ petition, Lordship.
Yes.
Lordship, on these circumstances and considering the name of the
Yes.
my say,
Nature of infraction.
considering the nature of the infraction as alleged, as also the submission of the learned counsel for the petitioner that the inquiry was not as per the procedure, this court at this stage directs the respondent number 3, 4 and 5 to complete the said inquiry proceeding based on the inquiry report dated 25/11/2006 within a period of 6 weeks from today. It is also provided that the proposed action shall be communicated to the writ petitioner, who shall thereafter be afforded opportunity to represent against the same. This order has been passed on the circumstances of the case and the nature of the charges which have been drawn up against the writ petitioner and the other employees who have been similarly charged and undergoing criminal trial, Lordship. So this was the direction, Lordship, and now
What did they do? Where's
now, Lordship, if Lordship comes to page 66 of the writ petition, Lordship.
yes.
Now, Lordship will find the inquiry report at page 50, Lordship.
50?
50, Lordship. Now, Lordship, if it's at page 54, Lordship, if I may read, Lordship, the relevant portion.
Yes.
Clause 5, Lordship, page 55, clause 5.
55 clause 5 or 54?
55, Lordship, 55. It starts, my name starts from 5.
Statement Ashok Kumar Rai.
Lordship.
Page 54 is at 3.
Page 55, Lordship. The relevant portion, Lordship.
5.
Lordship.
Yes.
That Shri Ashok Kumar Roy may have forged the signature as he had often been practicing in the handwriting book. So that is the only thing, Lordship, that they hold.
May have forged signature. Practicing whose signature?
Lordship.
Practicing whose signature?
Lordship, we don't know, Lordship, because Lordship, the allegation is that Lordship checks were issued, Lordship, and money was withdrawn.
Who withdrew the money?
Lordship,
The
we
peon?
don't know, Lordship.
No, from this from these.
Lordship, if I may read the entire inquiry report, if Lordship allows me.
It is a 1006 one.
Lordship, which was subsequently given to me after intervention of this Honorable Court.
Right.
Lordship, page 52, Lordship.
Yes.
The inquiry committee, which has been assigned with the task of inquiry into the alleged fraudulent withdrawals of college funds, has over the past 1 month or so has been able to summon the persons alleged to have been responsible for the fraudulent withdrawals, and also those whom the committee thought would be able to provide release into the matter. Those whom the committee summoned were the following. Number 1, Shri Arbor L. Thumoit, son of Mr. L. Ramdor Lawai, Maulai Nanglum Shillong, and working as library bearer at Ledkin College, was summoned and appeared on 27th September 2006 and 26th October 2006 at 11 am and 10:30 am respectively. Statement. Reporting before the inquiry officer, Thumoit on 27 gave his statement wherein he has confessed his involvement in the withdrawal of the college money from the Canara Bank extension counter, Ledkin College, and also claimed that the signatures at the back of the checks were his handwritings. The checks that he withdrew the cash and the amount against them were so and so. These were the Lordship amounts. Then coming to point number 2, Lordship, he stated that the check number so and so dated 11/11/404 amount rupees 75,000 was the first check that he had withdrawn money. It was Sri Leslie, laboratory assistant, zoology department, who gave him the check and asked him, Sri Thumoit, to withdraw the money from the bank. He obliged, but had not come to know that it was fraudulent until when he was given 5,000 from it and told by Sri Leslie that it was fraudulent. Point number 3, Lordship. He stated that the above 4 checks were given and asked by Sri Leslie L. Maulong on different occasions to withdraw the money, and that for each withdrawal he was given by Sri Leslie a sum of rupees 5,000. This means that he had received from Sri Leslie a total of 20,000 rupees only in all. He stated that the handwritings of all the above 4 checks belong to Sri Leslie L. Maulong, including the forging of the signatures of Principal A. M. Marbinyang, check number so and so, and that of Sri K. K. Pun, check number so and so. Point number 5, except that first check number so and so, he stated that Sri Leslie Mayong had written the other 3 checks and forged the signatures of Dr. K. K. Pun in the laboratory zoology department in his presence. He knew that he met Sri Sanjay Das Gupta when on 2 occasions he and Sri Leslie L. Mayong visited Sri Sanjay Das Gupta and spent time with him at the modern scientific stores, Police Bazaar. Sri Thumoit reaffirmed his statement when summoned again on the 26th October at 10:30 am. Now, Lordship, coming to number 2, Sri Leslie L. Mayong, son of Sri E. Nongbri Dingnong Maudendyang, and working as laboratory assistant, zoology department at Ledkin College, Shillong, was summoned and appeared on the 27th September 2006 and 26th October 2006 at 11 am. Statement. Reporting before the inquiry officer on 27 September 2006, Sri Leslie gave his statement wherein he stated that he was not involved at all in any way in this case of fraudulent withdrawal of the college money from the Canara Bank, and that he came to know about it from newspaper reports. But he stated that he often used to come to the office of the accountant and helped him out on certain occasions with entries in the acquaintance register, area bills, and with deposits in the Canara Bank extension counter. If I may continue, that he used to write accounts of checks in some checkbooks when being asked by the accountant. Sri Leslie reaffirmed his statement when summoned again on 26 October at 11 am. Sri Ashok Kumar Roy, son of Sri B.D. Roy, campus quarters, Ledkin College, Shillong, and working as lower division clerk at Ledkin College, Shillong, summoned and appeared on 4th October and 26th October 2006 at 11 am and 12 noon respectively. Statement. Reporting before the inquiry officer on 4th October 2006, Sri Ashok gave his statement wherein he stated thus, that he denied his involvement in the fraudulent withdrawals from any of the accounts of the college. When summoned again on 26 October 2006 at 12 noon, Sri Ashok revealed the following: that Sri K.K. Pun, then acting principal, told him about the fraudulent cash withdrawals, and that Sri Pun 2006, when Sri Pun was in the office 8 p.m., desperate of how writing book, that Sri K.K. Pun has requested him to settle the matter with the auditors, and for which he would be given rupees 50,000. That Sri Sanjay Das Gupta had come to the college on 10th May 2006 at around 4 p.m. and met Sri K.K. Pun, acting principal, and that the latter had requested Sri Gupta to make arrangements for vouchers against the missing checks, but he had with him at the moment only one for the moment of rupees 1,25,950 and one for the moment of rupees 1,25,950, and agreed to do the same for the other checks and promised to come the next day. That Mr. Pun had come to the college on 18 May 2006 and told him to hand over the bills and that he should resign his job, and that he suspects Sri Madhu Kumar Thapa for arranging the bills against the missing checks. Now, Lordship, number 5, Sri Madhu Kumar Thapa, son of Haste Bahadur Thapa, campus quarters, Ledikin College, Shillong, and working as Daftri at Ledikin College, Shillong, summoned and appeared.
Okay, that's enough.
Lordship.
Now, the only thing. Now, your case here is that this inquiry was generated as far back as in 2006, and this court given orders that yes, Mr. Sen. Now, where's the order impugned? Now, again, they did fresh inquiry.
We have taken we could not compensate, Your Lordship, because they have approached this honorable court against our decision, and my lord has stayed. So we could not initiate the.
You drop it.
Fresh.
I mean, you render your findings.
So what I'm saying, in the meantime, what happened, Your Lordships? He has retired from service on 31st May. Now, my lord, we are unable to complete the proceeding. My lord, could not even initiate because of the stay granted by this honorable court. So, my lord, here admittedly one thing is there, my lord, the substantial delay. 2006 and now we are, my lord, almost 20 years. Now, my lord, here your lordship will appreciate one thing, my lord. This person, my lord, he has embezzled a huge amount of money, almost around 2 lakhs.
Where's the prima facie?
No, lordship, criminal cases are pending.
Let the criminal case go on.
Criminal cases are pending, my lord, and he has caused loss to the college. And my lord, I'll just refer to 2 decisions. I'll not trouble my lord.
No, Mr. Sen, you have to address as to why. The orders of this court are very specific that, you have to take action, fine, you're given that latitude on the basis of the inquiry report is generated as far back 25th November 2006. Usually it will not done also. So, okay, fine, you generate whatever orders subsequent to this based on inquiry report. But what you have sought to do is that you sought to.
Lordship, at page 66, Lordship.
Yes, you sought to a fresh inquiry.
Lordship.
Fresh inquiry.
Then this court not allow fresh inquiry.
Fresh inquiry, my lord, only for the reason, my
allow
lord.
you to proceed from where you stopped.
My lord, fresh inquiry, my lord, because we looked into the inquiry report, my lord, that is basically in preliminary in nature. Then you realize, my lord, those standard norms were not followed. So, my lord, considering the gravity.
Did you go and appeal against this order?
My lord, the gravity of the offence, my lord, we have
If
decided.
you so much, then you should go and appeal against this court's order
No.
and said that the single judge was wrong. We want to have fresh inquiry.
No, my lord, what your lordship, my lord, that was very reasonable, my lord. We looked into, my lord, nature of the order.
Any other circumstance, Mr. Sen, 2006 inquiry over, would have quashed everything. You're all gone scot-free. Forget your substantial loss.
My lord, only my lord.
The only thing is to quash the entire department's proceedings.
I leave it to your lordship. The only thing, my lord, similar nature case, my lord, 2 decisions I have come across. There's a substantial delay. Now the apex court has said, my lord, when embezzlement and other things are there, substantial ground of delay, that should not be a ground for.
So what punishment do you propose then? Inquiry report.
Punishment, my lord, if we can prove only, my lord.
Exactly. What punishment? Now you have the inquiry report in your hand.
My lord.
What the recommendation of inquiry officer?
Well, we are yet to, my lord.
Exactly.
We have not done.
Exactly. That is where it lies. So prima facie, from what materials you've collected in the course of inquiry, Mr. Leslie. So what's happened, Mr. Leslie? He's in jail.
No, he's facing, my lord.
No, and now there's corroborative evidence with regard to his complicity with signing all the checks and all.
No.
Fine. We're not going to go there. It's not a criminal trial. But the only thing is that you have inquiry report. You have to generate other orders based on that. What's the recommendation based on inquiry? Then what is the the culpability of the petitioner? So where do you stand? Now you can't, like, just disregard everything, disregard a court's order, and have a fresh inquiry to try to, to hang those people who have caused, who have embezzled.
We have not disregarded this court's order.
Even if
My
there's
lord has
embezzlement,
looked into, on the basis of the records, to pass a necessary order. So, my lord, we considered it afresh, my lord. We found that there are a lot of things, my lord. Proper inquiry was not done. So, we have decided to hold a proper inquiry. Give me those decisions. You have given the copy to the court.
Is he what, entitled to pension or something? No.
No. Retirement benefit, yes. Pension, my lord, deficit.
Terminal benefits are there.
Terminal benefits.
Those benefits are there.
Yes.
My lord, 2013 6 SSC 530, my lord, para 18.
Yes.
Para 18, my lord, if I can read it.
Yes.
The court tribunal should not generally set aside the departmental inquiry and quash the charges on the ground of delay in initiation of the disciplinary proceeding. As such, the power dehors the limits of judicial review. In the event that the court tribunal exercises the power, it exceeds its power of judicial review at the very threshold. Therefore, the charge sheet or show cause notice issued in courts of disciplinary proceeding cannot ordinarily be quashed by the court. The same principle is applicable in relation to there being a delay in conclusion of the disciplinary proceeding. The facts and circumstances of the case in question have to be examined, taking into consideration the gravity and magnitude of charges involved therein. The essence of the matter is that court must take into consideration all the relevant facts and balance the way with the same so as to determine if it is in fact in the interest of clean and honest administration that the judicial proceedings are allowed to be terminated only on the ground of delay in their
Uncooked. So you cook it until it's ready.
Other thing,
so whether you accept you make recommendations. You
Lordship, here, my lord, I'll just put one thing. Tomorrow, suppose he is convicted, my lord, he is facing trial, your lordship. And the other decision, my lord,
yes.
That is 2012, my lord, 11 SSC 565, para 12. SSC 2012 11 SSC 565, para 12. Well, they have discussed all other earlier decision, and came to the conclusion, my lord. Thus, the law on the issue can be summarized to the effect that the charge be subject matter of challenge. It does not adversely affect the right of the delinquent unless it is established the same has been issued by an authority not competent to initiate the disciplinary proceeding. Neither the disciplinary proceeding nor the charge sheet be quashed, and it is as it would be premature stage to deal with the issue. Proceedings are not liable to be quashed on the ground that the proceeding had been initiated at the belated stage or could not be concluded in a reasonable period unless the delay creates prejudice to the delinquent applicant. Gravity alleged misconduct is relevant factor to be taken into consideration. So, my lord, here embezzlement.
Now, Mr. Sen, what do you propose to do? Tell the court. What do you want to do with this proceeding?
My lord, there is no bar to continue with the proceeding, your lordships. Even after retirement,
so
we can continue. Since it was initiated before his retirement, my lord, we come, my lord, lordship grants us a reasonable time, 3 months. We conclude it, your lordships. With otherwise also, my lord, considering the case and pending, your lordships, tomorrow he is convicted. And my lord, the charges are very, that can lead to total loss of confidence, my lord, on an employee. So
if they haven't lost any confidence by now, I don't know what confidence left to be lost. If
we have not proceeded with the inquiry after this honorable court passed this order.
2006, Yerga report generated. So if that doesn't, he'll not inspire confidence for sure. If 2006 you conclude the inquiry, report submitted, and you sit on it for 24 years or 20 plus years.
Well, delay is there, man. I'm not. 2006, 19 years. 19 years delay, my lord. That I am not saying, but lordship will see the facts and criminal, my lord. Had there been no criminal case, my lord, the thing would have been
inquiry.
My lord.
There's no materials against him at all.
But now
only one statement of